So the first route I want to talk about is the continuing power of attorney for property. And some of the patients here, when I go and talk to them about that, they say, well, I don't have any property. So basically, I don't need a power of attorney. And so I need to point out to them that it covers not only real estate or house, but also banking or your finances. That everybody really could use one of these documents to be in place because it may come in handy. You may never need it, but it's always good to have if you, when the time comes, if you do need help with decision making. So what is capacity to give continuing power of attorney? And may I say that the word continuing just means you can make the power of attorney when you're capable, but the legal validity of the document continues if you become incapable. That's what the continuing part is. And the word attorney, although that's used for an American lawyer, but in this case it just means an agent or a substitute decision maker. So to have capacity to give a power of attorney, you have to understand what kind of property you have. That you have a bank account, and you might the bank. You don't have to have an exact idea of how much you have, but you know where it is. You know what obligations you owe your dependents. If you support someone, you know that you have to pay certain bills, and you also should appreciate that if you make a decision or you don't make a decision, like you leave a bill waiting or you just ignore a debt, what the consequences would be. So that's just it's a pretty basic level, and capacity, by the way, is different for different situations. So that's the sort of definition of capacity for the attorney, power of attorney for property. You should also know that if you give someone the power of attorney for property, that person really needs to keep you in the loop. You should be really working together with that person to manage your finances. So the attorney has to keep accounts, should consult you regarding the decisions, and you should also be aware if that attorney doesn't manage your property prudently or honestly, that your value of your property could decline. And that you should be aware that the attorney could misuse the authority that you've given to them. And that all goes into the sort of idea of, are you capable of understanding what it means to give a power of attorney? So these are important. Sorry, my screen just went black, Darren. Maybe you can help me. Who can be an attorney for property? Well, you have to be at least 18 years old. You should ideally should have some financial abilities, and certainly be trustworthy and responsible. And also, you should be willing to do it. I often speak to people in the hospital who haven't talked to the person that they're thinking of appointing. So that's really important that you should talk to them. Sometimes people are very insistent that they want to appoint their one child when it's really the other child who is ready and willing to do it. So that's very important. And the residency is important too. Some people don't have relatives in the city, which is a problem. But if they can travel easily, if it's not going to be a big deal for them to come to Toronto and help, then it's okay. But it's something that should be considered. Now, there is the option if the person doesn't have any family of the trust company being appointed, but generally that requires the value of your assets to be about $1 million. So it's not an option for a lot of people. And the person, as a last resort, if a person doesn't have anybody, it's the public guardian and trustee. Okay, so duties. As I mentioned, the attorney has to be honest and act with good faith in the performance of the duties and do everything for the incapable person's benefit. They should consider the person's well-being too. You may have to spend more of the person's money to hire, say, a personal support worker if that's what's required. You should, and also the attorney should explain what they're doing and what their duties are to the person. It shouldn't be a matter I've heard of a lot of cases of attorneys just sort of going their own way and doing their own thing and not even considering what the person who granted the power would want, because they think they know better. And they think maybe, if I use Dad's money to invest in this condo, he would approve because he was really great with money and he knows that the value of my asset would improve. And he can move in about a couple of years. Well, that's not very much going to benefit the person that the attorney's looking after. So you really have to know that you have to really know that the attorney's going to do what they do for you, not for themselves. Now, you can appoint one attorney or you can appoint more than one. The thing is, if you only appoint one, you should appoint an alternate in case that one can't do it or won't do it for some reason. If you appoint more than one, you in the document, there's a space to say how they will make decisions, and the phrase is jointly or jointly and severally. Severally just means individually. So some people think, oh, well, yeah, I want them to be able to agree. They have to agree. But what if one of them travels a lot for work and is just not around? Logistically, that might make things difficult if there's a decision that has to be made immediately. So it's something that depends on the circumstances of the family, and it also depends how they get along. Now, if you appoint 3 people, you might put in your document that they have, that it has to be a majority, 2 out of 3 who agree, just to be able to have some kind of a decision-making process. The thing that the trap that some people fall into is appointing, say, all of their children. If they have 3 children, they think they have to appoint them all because they don't want to slight someone. But that may not be appropriate if one just isn't very responsible with money, or the children don't get along, and so on. So this is a very important decision, not just the identity of the attorney, but how many. Now, the powers of attorney don't have to be completely wide sweeping. They could be limited. For instance, you may own a house that you want to give to someone in your will. Well, you may say in your power of attorney that the attorney is not permitted to sell that house while you're alive. Or you might not agree with giving money to a political party or a particular cause, or you might not want your money used to support a relative, for instance, who's always in debt or something like that. You can place these restrictions and conditions in your power of attorney. You can also set up a period of time for which the power of attorney is effective. But the important point is that you don't want to limit the attorney's powers too much so that they aren't able to act when you need them to. And also, if the person owns property outside of Ontario, you have to remember that the Ontario document may not govern. So you may need a power of attorney for the province or country where the property is located. So you have to look into that, because some people think it just governs everything. Okay, so date of effectiveness. So you have a choice with powers of attorney for property. It can come into effect the day it's signed and witnessed, or you can postpone the date that it comes into effect. And if you say nothing in the document, then it would come into effect when there's been an assessment of the person's incapacity. Or you could just spell it out, on an assessment by my doctor or an assessor. But you can spell it out, or you could leave it blank, but you want to make sure that you've indicated that it comes into effect either while you're still capable or only when you're not capable. And I know some people have questions about when do you know when to take over, if there's not sort of a formal assessment. Sometimes it's a matter of just discussing it with the person that you're helping, and the person is finding it a little bit too much to manage their property, and they trust you, and basically say, go ahead, and as long as long as the bank is in agreement and you've got the document there, you can go ahead. There is a whole thing about making sure that you've deliver the documents that the bank needs. Usually it's a notarized copy and some identification, and the bank is on the lookout for any fraud, so you know, you have to prove that you have been given this authority legitimately. But you can state when the document starts. Okay, and there's another part in the document where you can provide for your attorney to receive compensation for their work. It's not that much. It's in the statute, it's up to 3% of income, as you see there, and a portion of disbursements and the annual value. But you could also say that the person gets no compensation. Usually this would be in a case of a family where perhaps your child is going to be the attorney, and this is the child you're going to leave all your property to in your will. So the child isn't really going to be interested in spending your money now necessarily, and it's only a small portion. So if you leave it blank, they can claim under the statute. If you put no compensation, that's it, or you can also put a fixed amount. And then executing the document or signing the document has to be done in front of 2 witnesses, and the witnesses have to be at least 18 years old, and they can't be you know, the attorney, him or herself, or their partner or spouse, or their child, and they can't be someone who is actually under a guardianship order themselves. So, and so ideally the witnesses should be neighbors or friends, nobody really related to the attorney at all. So when I do the documents here in the hospital, we have wonderful partners with Bank of Montreal who send people over to be volunteer witnesses, and so you always have to have a witness to make it official. And when does it end? Well, it ends when it's only useful when the person is alive. So it ends on the death of the grantor or the person who gave it. It ends when the person could also revoke it at any time, or if you make a new one, that ends the authority of the other one. And also if the attorney dies or becomes incapable or resigns, it ends. If the court appoints someone to be the guardian of property, it also ends. So there is a bit of a system. If the attorney wants to resign, they have to, and they've already started to act as the attorney, they have to give notice to anybody who had dealings with them regarding that person's property, so that's properly done. So that's the power of attorney for property. I'll take some questions at the end, but I'll just go through